itself justified. So one looks at the micro of the particular case. And there's three cases that we rely on to try to support that. The first is Re G, which I mentioned already. That's in the authorities bundle, and I'd be grateful if you could turn it up, please.
Yes.
At tab 7. And page 151, in which Lord Hoffman, at paragraph 12, explained that there are some macro reasons. There are some reasons why excluding unmarried couples in general, on a macro basis, may be rational. And he described those over the page into paragraph 13. But then, over at paragraph, then at paragraph 13, about 4 lines down, he said, if, therefore, it was rational to adopt a bright line rule to determine what class of people should adopt children, there would be much to be said for Article 14. But over the page at paragraph 16, 4 lines down...
This is Article 14 of the Northern Ireland Statutory Instrument, not the Article 14 that we're talking about in the case.
Sorry, yes, you're absolutely right. Yeah, right. Thank you. Important. And then over at paragraph 16, 5 lines down, Lord Hoffman says, a bright line rule cannot be justified on the basis of the needs of administrative convenience or legal certainty, because the law requires the interests of each child to be examined on a case-by-case basis. So he's essentially making the point there. A bright line rule isn't justified by the additional cost or inconvenience of individual consideration, because that individual consideration is, in any event, required by the law. Over at paragraph 18, then he says, it's one thing to say that in general terms, married couples are more likely to be suitable adoptive parents than unmarried ones. It's altogether another to say that one may rationally assume that no unmarried couple can be suitable adoptive parents. Such an irrebuttable presumption defies everyday experience. So the macro reasons for having the categories themselves fell away because individual consideration was in any event required. And the finding that there was a breach of Article 14 was based on the conclusion that, well, in this subset of cases, unmarried parents, the exclusion of them for adoption may be unjustified. And it's one of those cases where a number of unmarried couples, the exclusion of them for adoption may be unjustified. So it's not the whole category where discrimination is unjustified. It's only a subset. It's only a particular class of them. Now that was Lord Hoffman. The majority agreed with him. So Lord Hope at 56, Lord Mance at 135. And we say that the same approach applies here, that there wasn't a bright line rule which excluded individual consideration of issues like residence, so the relevant factors here. We say that wasn't justified because individual consideration was required in any event. So
to what extent? The policy requires that you're resident before the 1st of January 2022 in Ukraine, that you're a Ukrainian national, and that you have the necessary familial contact in the United Kingdom. If those 3 things are met, isn't that it? The Home Secretary doesn't then go and look and see whether you're a sort of person we want in this country or anything evaluative like that.
No, on the particular point of residence, so is individual consideration given to residents anyway? Well, one of the criteria in the scheme is whether they're residents, in that sense. There's the evidence flexibility policy that we looked at before, which may be applied. So residents may well be examined at that point, but even if it's not, the next stage is to consider leave outside the rules. and if the question of residence is raised in that process and it's relevant, then it can be expected to be considered. That's the policy that I took your lordships and your ladyship to earlier, said there should be individual consideration of the particular facts of the case.
Really, when you get to the leave outside the rule stage?
Yeah, precisely.
Prior to that, there isn't much individual consideration. There are just three boxes which are either ticked or they're not.
Yes, although one of those boxes is residence.
Yes.
So it's not inevitable that residence will be considered, but it's one of the boxes that needs to be. So so that's Re G. Another case which I hope assists is the case of McLaughlin, and that's at tab 16 of the authorities bundle. Could you turn to that, please? Page 428. McLaughlin was a Northern Ireland order which concerned something called widowed parents' allowance. And the order limited widowed parents' allowance to either married or civil partnered couples and excluded unmarried couples. And the Supreme Court said that that was a breach of the claimant's Article 14 rights. And again, a similar approach was adopted. Could you turn, please, to paragraph 38 of the case, which is Baroness Howe's judgment. So, paragraph 38, towards the bottom of that paragraph, she asks the key question, is it a proportionate means of achieving the legitimate aim of privileging marriage to deny Ms. McLaughlin, the claimant, and her children the benefit of Mr. Adams, her deceased partner, contributions because they were not married to one another? In my view, the answer to that question is manifestly no, at least on the facts of this case. She drew attention to the purpose of the allowance, which is to diminish the financial loss caused to families with children by the death of a parent. And then down in paragraph 42, she gave her overall answer to that question posed in paragraph 39. She says, this is not a difficult conclusion to reach on the facts of this case, where the couple lived together for many years, were recognised as doing so for other purposes by the Department for Communities, and were parents of all of the children involved. So those were her key reasons for finding it's not proportionate. And it's important to read Baroness Hale's judgment together with that of Lord Mance, because three of their lordships, three of the justices agreed with Baroness Hale, and the three included Lord Mance. And then Lord Mance gave an opinion, and Baroness Hale agreed with that, along with the other two justices, so they probably need to be read together. So if we can turn to that, please, it's 446. And paragraph 53 of Lord Mance's conclusion. I take the points made by Lord Hodge, JSC, that it's not always easy to judge how different benefits interact and how easy they may be to administer. One of the points that Lord Hodge made in those paragraphs, 85 to 87, was that, well, it may be difficult to determine whether a person was cohabiting and whether they were a long-term partner. And Lord Mance dismissed that. He said, the position of couples who are neither married nor civil partnered is already catered for in other situations known to the law. What that meant was that there are other circumstances in which the law requires an assessment of those very facts. So whether the couples are cohabiting, whether they are long-term. And so Lord Mance essentially dismissed the bright line rule argument. He dismissed there being any justification for not giving individual consideration to the relevant facts. And so, again, we rely on that authority for 2 points of principle. The first one is that stage 1 of the analysis is to ask whether there's a justification for having a bright line rule, which excludes any individual consideration. If there is no justification for that bright line rule, then stage 2 of the analysis is to look at the facts of the particular case, as Baroness Hale did here. So one asks whether exclusion from the benefit was a proportionate means of achieving a legitimate aim on the particular facts of that case. The final authority I'd like to go to is a European Court one, just to make the key point that at times, when there's no justification for a bright line rule, the European Court will look at whether a difference in treatment was proportionate by reference to just the particular subset, just the particular facts of the case brought by the claimant. And this is the case of Ponomaryov. It's in Authorities Bundle, tab 31. Page 1074. The applicants were children who were charged fees for their education. And one of the criteria as to whether they would be charged fees was essentially nationality. So were they Bulgarian, or did they have a similar immigration status? And the European Court held that there was a breach of Article 14. And I'd like to come to the reasons to explain why they came to that conclusion. Firstly, could you look, please, at page 1080, paragraph 32. 1080, paragraph 32 shows the law in question. So it explains the law which excluded the claimant from the benefit, and that it was primarily based on nationality, but also whether they had a permanent residence permit and so on. And then the conclusion, so far as relevant here, is expressed in paragraph 59 onwards. Paragraph 59, the European Court said, in assessing proportionality, the court does not need, in the very specific circumstances of this case, to determine whether the Bulgarian state is entitled to deprive all unlawfully residing aliens of educational benefits, which it's agreed to provide to nationals. The court will have regard primarily to the applicant's personal situation. And focusing on the applicant's personal situation, in paragraph 60, the European Court noted that there was no justification for excluding them in terms of the need to stem or reverse the flow of illegal immigration. And that's because in the particular circumstances of their case, the authorities had no objection to them remaining in Bulgaria. They'd made no attempts to remove them. Then in paragraph 61, the European Court note, nor can it be said that the applicants tried to abuse the Bulgarian educational system. It wasn't one of those cases where they came to Bulgaria just to use the education system. And it explained why on the particular facts of their case, there was no risk of abuse. That justification wasn't applicable. 62, the authorities didn't take any of these matters into account. And then paragraph 63, therefore, there is a breach of Article 14. And the European Court there didn't explicitly deal with the bright line point. It didn't ask the question that we've seen in McLaughlin and Ricci, is there a justification for having a bright line?
Well, it did. It said it didn't need to decide whether or not the Bulgarian state was entitled to have a law like that. It moved straight to the question of whether there was discrimination, unjustified discrimination on the facts.
Yes.
So what help do we get from that?
Well, I was going to deal with that. There was no suggestion in that case that a bright line rule was justified, that there was any reason for not having individual consideration. The key reason for relying on this case is just to show that there are some authorities in Europe which address the Article 14 question by looking just at the particular facts of the individual case.
Some authorities, one authority, or are you saying this is typical of other cases?
it's reflective of other cases. Another one we mentioned in our skeleton argument is a case called Derby in Italy, which relies on this and takes a similar approach.
As I said, I'm not sure how this reasoning helps your argument.
The domestic authorities, as is often the case, is explained in more detail. And so McLaughlin and Regi are probably more helpful overall. But this really illustrates that the European Court doesn't only ask itself the macro question, whether the rules as a whole were justified. In certain cases, it looks at the micro question, so whether on the individual facts of the cohort, the claimant's case, there was proportionality. Now, the final authorities...
But they actually, don't they, in paragraph 62, they say they don't have to decide whether the law is lawful, if you like. But in paragraph 62, they seem to decide that it's unlawful, because the reason why the authorities didn't take into account the particular facts of the case of these Kazakh children was that they weren't allowed to by the law.
Yes. And so...
It's a rather curious decision in a way.
That's absolutely right. It was the combination of all of those factors together, as is often the case in European authorities. But as I say, the key reason for relying on it is to show that consideration of the specific facts of the case or the cohort is appropriate. The last authorities in respect of ground 2 that I just briefly mentioned are the cases of Agiarco and MM, which are set out in our skeleton argument at 42 to 43. Those were Article 8 cases, and they said there are two separate questions in that context. One is the systemic question, so whether the immigration rules themselves are compatible with Article 8. There's a separate question, which is whether the decision in the particular case was compatible with Article 8. And the reason that those are separate is because of leave outside the rules, that there is a discretion to give leave outside the rules, where even if the rules in the scheme themselves aren't met, the decision maker can go on and consider that separate question. Now, the main reason for mentioning those is that the appropriate approach in an Article 14 case, we say it is as follows. Firstly, to ask whether there is a justification for a bright line rule, so the Regi, the McLaughlin question. If there's no justification for that rule excluding individual consideration, then the second question is, on the particular facts of this case or this cohort, was there proportionality? Was the exclusion proportionate? And if not, then there's a breach of Article 14. And Section 6 of the Human Rights Act requires the decision maker to grant leave in those circumstances. It can do so through the prism of the leave outside the rules process. There's nothing in that that prevents it granting leave compatibly with Article 14. And so that's, to that extent, this context mirrors Agiarco. If I can turn then to the upper tribunal's approach and why we say that they were in error in respect of that. If you need the judgment, it's in the core bundle, and it's in, if you have tabs, it's tab 12, and if not, it's page 102. That's where the case starts. The key reasoning is between paragraph 50 and 59, and paragraph 50 is page 119.
Is there any controversy about the about paragraphs 41 to 48 of the judgment of how, in principle, you approach objective justification?
Not from our perspective, no. And there's been no suggestion by the respondent either.
So we're on 49, Home Secretary's stall is set out, and then 50 to 59, as you say.
Exactly. And we say as well, 51 to 53 are reasons for having the scheme rather than reasons for the difference in treatment. And case law, for example, the case of A against the Secretary of State for the Home Department, says that the correct question is, was the difference in treatment justified, not the underlying scheme was justified. And so we say paragraphs 51 to 53, you don't need to, the key thing to look at in terms of justification is paragraph 54 onwards. The reference to that, if you need it, is authorities tab 5, page 59, paragraph 68. In paragraphs 54, 55 and 56, the upper tribunal addressed the question as to whether a bright line rule which excluded individual consideration was justified, and it decided that it was. And the key reason it gave as to why it was justified is the cost that there would be in individual consideration, the resource burden that there would be in individual consideration. So, for example, in paragraph 54, it looks at the question of residence and decides that giving individual consideration to residents in the way suggested would increase the resource burden. 55, similarly, resource burden in assessing whether there's a right to return. And then 56 looked at the question generally, the merits in having a bright line rule as it saves costs. And we say they erred there because there would be no cost saving. The individual consideration was required in any event. I've already addressed your lordships on this to some degree, so I'll deal with it very quickly. But individual consideration, for example, on residence was required through either under the assessment of the criteria under the UFS scheme itself or under assessment of whether to grant leave outside the rules. There's no cost saving there's no additional cost in looking at residence because it's required in any event. So we say this is equivalent to Rigi and McLaughlin, where there was no justification for the bright line rule in Rigi because the law requires it in any event, and in McLaughlin because there's a simple way of doing it that's already provided for under the law.
What's said against you on the facts is that the Home Office were prepared to be pretty light touch about whether Ukrainian nationals applying were or weren't ordinarily resident in Ukraine on the 1st of January 2022. Ordinarily resident isn't defined, but it doesn't just mean that you spent the nights of New Year's Eve and New Year's Day there. But they say it's much more difficult question if somebody who isn't a Ukrainian national says, I was ordinarily resident in Ukraine on the 1st of January. So to say that residence always has to be looked at anyway may not get you far.
The same applies to both sides, both aspects of the scheme, the people who are excluded and people who are included. And that's because people who are included includes that very potentially large group of third country nationals who fall within 7.1b. With all of those, the same question may be asked. The policy provides for evidential flexibility. So for decision makers to say, we're not convinced, we need more information. And that applies both to those who qualify and those who don't. So we say there's no difference between the two categories. And it's worth noting that in the circumstances of this case, there was no lack of clarity about it. There may well be a number of third country nationals where there's just no question as to whether they were resident, but it's very easily established. And this case is an example where they had evidence of having visas, paper evidence of having visas. So that's the residence point. In paragraph 55, the question as to whether it will involve additional resources to assess whether the individual can return to their country of origin is raised. There will be, of course, clear cases where there's no doubt that the individual can't return to their country of origin. And those cases may include refugees, for example, where refugee status is declaratory. And in this case, we've seen the reasons given in the decision maker's decision about return to the country of origin. The decision maker said, I accept you've explained the reasons why you can't return. Query whether that actually means that they accepted the individual can return. But this wasn't a case where the decision maker was saying, it will cost far too much to assess whether you can return to your country of origin. It wasn't that sort of case. If it had been that sort of case, then there may very well be a justification for excluding them. So the cost of the assessment of return to the country of origin, if it's unclear, may well be a justification for excluding them. But that's a different category. The fact that it may cost, that there may be a justification for discrimination in another category doesn't mean that there's a justification in this one. And the cases of Rigi, McLaughlin and so on are examples of that. Ponomaryov may also be an example of that.
It may be the end, upper tribunal aren't really just talking about financial cost. If the purpose of your scheme is to get people to safety before they're killed, such that weeks, days matter, it might be thought that you don't want to create a simulacrum of our asylum system, which can take years to produce an outcome.
Yes.
Is that a legitimate consideration?
Yes, absolutely. And we say the fact of this case isn't one of those. So in this case, there was a decision made as to whether they could, for example, whether they were resident in Ukraine, and the decision was made that they were resident. There will be a clear cohort where those conclusions can be readily answered without any delay, without any impact on other people. If it was one of those other cases where the Secretary of State was saying, I'm sorry, we're going to have to do a full asylum process to actually determine this question, and that's going to cost a lot, both in money and lives, then that's probably going to be justified, the discrimination in that case. But the fact that it's justified there doesn't mean it's justified here.
I follow.
Another point made in those paragraphs is the risk of discrimination, but I'm going to deal with that, if I may, in ground 3.
Yes.
We say, other than that, there's no other justification given by the upper tribunal for having a bright line rule. And therefore, what the upper tribunal should have done is to go on to consider whether exclusion of the appellant's cohort, so just this specific group of people who can't return, was itself proportionate, whether that was justified.
So just pausing there, the definition of the cohort, people who can't return, how does one establish whether or not a person can't return to their country?
Well,
for the purposes of this scheme?
The cohort we identify is people who show that they can't return. In a category of cases, that will be clear, and in the category of cases, the Secretary of State will readily establish that. And those are the only cases we are concerned with.
So what's your case here? That just because the appellant comes from Afghanistan, it's clear he can't return. Is that it? I just want to understand what the submission is.
Yes, we say that excluding the cohort who show they can't return is a breach of Article 14.
I understand that you're saying that. What I'm trying to understand is why you say that the appellant and those in his group can show that they can't return, and is it your case that it's simply because they come from Afghanistan?
Oh, I see. I'm sorry.
No, it's my fault for not asking a clear question.
the question of what proof is required, the simple answer is no. We don't say simply the fact that they say they can't go, that they're from Afghanistan is sufficient.
Right.
But the question as to what proof is required would be a matter for the Secretary of State.
So an assessment would be entailed in deciding whether or not somebody belongs to this cohort in the first place.
Take a refugee. If someone applied and said and gave evidence to show they're a refugee, so they had a declaration of it, then that would be sufficient in itself.
I see.
So we say that the upper tribunal ought to have gone on to consider A's particular case or A's cohort and failed to do so. And we say also that there was no justification for excluding A or his cohort from giving leave, and the upper tribunal identified none. The upper tribunal at paragraph 54 identified the risk of abuse that would arise if one allowed all third country nationals, that's not just this particular group, but all third country nationals who satisfied the relationship and sponsor criterion, there's a risk of abuse by allowing those in, because people who weren't resident would abuse the scheme and come over. And we say that doesn't apply to A's particular cohort. So there's no evidence that people would abuse the scheme, that large numbers of people would come to the UK if A's particular specific cohort only was allowed in. So it's a small group. And so we say that application, that issue doesn't apply. It's not a proper justification for this particular group.
So you now seem to be making submissions about a cohort as opposed to an individual. I mean, which is it, a cohort or an individual?
Well, we start with A's case, because the question in this case is whether there's a breach of his Article 14 rights by refusing him the visa. But it's necessary for us to define the reasons as to why we say refusal of him is justified. And we say why refusal of him is unjustified. Sorry. Yeah. And we say refusal of him is unjustified because he's shown that those criterion apply. So he's shown that he meets all the criterion for the Ukraine scheme, including residence, except for nationality, but he's also shown that he can't return to his country of origin. And the upper tribunal accepted at paragraph 2 that he's shown he can't return to his country of origin.
Yes.
And we say that those are the factors which demonstrate why his case was unjustified. I should deal with one more point in the upper tribunal's reasons, which is in paragraph 55, it raised the point, well, some third country nationals may not be able to return to Ukraine after the conflict, and that's a justification for excluding them. And we say that isn't a justification for the difference in treatment of A. And that's because, again, under 7.1b of the criteria, a potentially very large group of third country nationals can qualify in any event under the scheme. And there's no reason to think they will be any more likely to be able to return than A. Many of them may have temporary rather than permanent residence. And so we say there's no actual difference between the two groups. It's also worth noting that the Ukrainian president gave a decree which extended all temporary residence permits until 30 days after the end of the period of martial rule. And that's the reference for that is the supplementary bundle, tab 34, page 178, paragraph 19.
So did you rely on that in front of the upper tribunal?
Yes.
Right.
We say that when one looks at the main purpose of the scheme, which we say is to enable family members who were in Ukraine, who were put at risk by the invasion, to come and join a settled person in the UK and escape danger. When that purpose is looked at, there's no real difference between the appellant on the one hand and those who qualify in 7.1b on the other. That's really the key question. And that can be tested by asking, well, what would happen if he had permanent residence? Would that make a difference? And it wouldn't. There's no criteria within the scheme to say only those with permanent residence could come in. So we say that that's all evidence to show this isn't a critical aspect of the scheme, whether someone can return afterwards. It's not a basis for excluding one group or another. That's really the main thing that I wanted to say about ground 2. There's one case that I should deal with quickly because it was mentioned by the upper tribunal in refusing permission to appeal, which is the Court of Appeal's case of AB. This is in the authorities bundle at tab 27. And it was a case about a difference in the requirements as to how you give biometrics as between the Ukraine schemes on the one hand and the Afghan schemes on the other hand. And there was an argument that that breached Article 14 and that was rejected. And the critical thing to note about this case is it was a systemic challenge. It was a challenge that the system itself was breach of Article 14, not a challenge brought by an individual, as here, who says that his Article 14 rights were breached. And one can see that on page 1006, paragraph 5, where the Court of Appeal say, this appeal is therefore not concerned with the merits of AB's individual case, as to which we say nothing, but a wider systemic claim of discrimination. It goes on to explain this. The main reason for that was the Secretary of State agreed to consider biometric deferral in AB's case and was in the process of making a decision. So it's going to make a new decision in AB's case, and so the grounds concerning whether there was a breach of his Article 14 rights fell away. All that remained was a systemic challenge seeking a declaration in systemic terms that's set out in paragraph 4. And the paragraph that was relied on by the upper tribunal is on page 1022. It was paragraph 57.
Sorry, page
1022. There, the Court of Appeal, 3 lines down, noted Article 14 challenges are about differences in treatment between cohorts in relevantly similar situations. They do not involve individualised assessments, and it's that sentence that the upper tribunal relied on. An argument of this kind may assist AB beyond the limited context of this appeal, but it can't sustain a challenge to the policy. And we say what, well, the Court of Appeal there wasn't concerned with the kind of issues that are raised by this case. We say that that short sentence, they do not involve individualised assessments, needs to be read as if they was said Article 14 challenges to policy. So Article 14 challenges to policy do not involve individualised assessments. And it needs to be read in that way for 2 reasons. Firstly, the Court of Appeal said in paragraph 5, we say nothing about the individual cases. And also the last sentence of paragraph 57 suggests that the Court of Appeal considered that individual assessments may be relevant to AB's individual challenge, but not to a challenge to policy. The cases that I've gone to, such as McLaughlin and Reed G, which indicate that in this type of case, where there's no justification for a bright line rule, the court should go on to make individualised assessments of the particular claimant's case, the particular cohort, as to whether that was proportionate. The Court of Appeal in AB simply wasn't concerned with that sort of case. It wasn't concerned with, for example, the fourth aspect to Lord Ree's formulation for justification in Bank Mellat, which is whether there's a fair balance between the interests of the individual and the interests of the community. That sort of question raises individual assessments. But the Court of Appeal just wasn't concerned with those issues, so we say that it doesn't stand as an authority, that there can be never any consideration of the individual facts. So if I may turn to ground 3. Ground 3 is a very short ground. It's about the risk of discrimination. At paragraph 54 of the Upper Tribunal's judgment, drew attention to the concern that if third country nationals in general who meet the scheme's criteria are allowed in, then there's a serious risk of abuse. There's a risk that large numbers of people will apply who weren't actually resident and would seek to abuse the scheme. As your Lordship explained, that moved on to the suggestion that a higher residential standard would be necessary, and that itself went on to the suggestion, well, this would discriminate then. If one has a higher residential standard for some, then that's going to be, people are going to say this is discrimination. And we say that that point doesn't justify refusing leave to the appellant. It doesn't justify the discrimination in his case. And that's for 3 reasons. Firstly, the concern there was, well, the concern there doesn't apply to A's cohort. So in his cohort, residence has already been determined. It's been accepted that he was resident in Ukraine. And so there's no need to apply a higher or a lower evidential threshold. There's no discrimination in granting him leave. The same approach to his case has been taken with other cases. And so it's simply...
But there might be a wider concern in relation to cases that aren't cases about what you keep referring to as A's cohort.
Yes, and we accept that that although the court is concerned with his case specifically, that we accept that can be relevant, but we say that the risk of discrimination wasn't a possible justification for 2 further reasons.
So are you abandoning the first reason?
No, we sustain that, and we say the main question before the court is, was there a justification in his case or for his cohort? And we say no, because in his case, in that type of case, residence has in any event been established. There's no dispute as to it.
But the scheme isn't just designed, that's the whole point about this case, the scheme isn't just designed for the appellant and his cohort. It's a scheme that's designed to apply across the board. So there may be justifications for a general treatment of certain issues which might not apply in the appellant's case. But that's why the starting point is whether or not the scheme as a whole is justified in general.
And our response to that is that the ability to give leave outside the rules is focused on his particular facts.
Yes, but against the premise that he hasn't qualified under the scheme.
Yes, but if he establishes under the leave outside the rules consideration that he is resident, the key point here, then there's no justification in excluding him.
I see.
So that window allows for individual consideration of his sort of case. There's no additional cost in doing it. If the Secretary of State says, having done that individual consideration, yes, he's resident, there's no question of having to apply a higher evidential threshold. It's already been done, and so there isn't any discrimination. So that's our main point. But there's supplementary points, which is that it was a legal error to conclude that there's a risk of discrimination for this. And that's really for the reasons that I took the court to in respect of the 6th of May 2022 min-sub. This was where the civil servants who were writing the ministerial submission questioned, well, they said there's not really any difference between the approach that would be applied in the normal cases and the approach that would be applied in these cases. And that's because in normal cases, there's evidential flexibility in any event. We can ask for further evidence if we're not convinced. That's all we'll be doing here. So there isn't any benefit, there isn't any difference in treatment in doing that. The final point is really focused more on the asylum cases. So it's a point that I've already covered. Yeah, so I'll just leave it at those 2 points. So that's ground 3. The final ground is ground 4. In ground 4, we argued that the upper tribunal erred in finding that there was no less intrusive means which could be employed without unacceptably compromising the legitimate aims. The law first on that. The upper tribunal quote Lord Reed's approach to justification from the Bank Mellat case, a very familiar 4-stage test, question 3 of which is there a less intrusive means which can be employed without unacceptably compromising the legitimate objectives? And there are 2 cases which I'd like to refer to which are relevant to this particular context, so which answer that question in this type of Article 14, in an Article 14 case. And just in summary, what we seek to take from those cases is substantively pretty much the same as what we took from the cases in ground 2, which is that the key considerations in deciding whether there's a less intrusive means are firstly to consider whether the bright line, which excludes individual consideration, is justified. If it's not, then the courts go on to look at the facts of the particular case or the facts of the particular cohort and assess whether exclusion of them is proportionate, whether that's justified. So it's the same 2 points in substance, but just looked at from a different lens, from the less intrusive lens. And the authorities we rely on are set out in skeleton at 58 to 62, because I'd just like to look at 2 of them. The first of them is Brewster. Could you turn back to that, please? It's tab 12 of the authorities bundle. And this was a finding of a breach of Article 14 by a rule which excluded unmarried, uncivilly partnered couples from survivor's pension unless they satisfied the nomination procedure. And over at page 341, paragraph 62, the key reasons for the judgment are summarised. This is Lord Kerr's judgment. He noted, in the present case, no thought was given to possible difficulties with administration that might arise if the nomination procedure was not included in the new scheme which the 2009 regulations introduced. Indeed, even after the claimant's challenge was made, the Department for Environment of Northern Ireland has not been able to produce tangible evidence that there would be significant problems in administering the scheme if the nomination requirement was abandoned. Vague suggestions as to workability and the advantages of actuarial predictions were made, but these were not supported by evidence. It's also significant that in England and Wales, where a significantly greater number of applications required to be rejected, it's considered that the nomination procedure is not necessary. I consider, therefore, that the desirability of a bright line rule is at most of marginal significance in this case. A further aspect of the context that I should refer to is that Regulation 25 of the regulations which governed the pension required in any event that the decision maker should consider the point at issue here, which is whether the people were cohabiting and whether they had a sufficiently long-term relationship. And so it's a similar point to Re G. There's no benefit in terms of cost or resource saving in a bright line rule, because consideration of the relevant factors is required in any event. And that's paragraphs 22 and 39 of the case describe that aspect to it. Over at 67, Lord Kerr comes to his conclusion. He notes that the reasons earlier given, I consider that the objective of the particular provisions of the regulations must have been to remove the difference in treatment between a long-standing cohabitant and a married or civil partner of a scheme member. And then at the end of that paragraph, I consider that there is no rational connection between the objective and the imposition of the nomination requirement. And this also fails to meet the third and fourth standards in Lord Reed JSC's formulation. So in other words, there was a less intrusive means that was available in that case. And what we seek to take from that is that the court's, firstly, the key aspects of the finding was that there's no, a bright line rule isn't justified, which excludes consideration of the relevant factors. And secondly, refusing the benefit to the claimant and his group, long-term cohabiting partners, was disproportionate. And it was disproportionate there because it was inconsistent with the primary purpose of the scheme. The final authority that I'd like to refer to in this context is Van Riel. It makes a similar point. It's in the authorities bundle at tab 23, page 858, it starts at. Van Riel was a Windrush case. So it was a challenge to the 5-year rule for citizenship. That rule is that to get citizenship, one has to have been in the UK 5 years before the application was made. And that was found to breach Article 14 of the ECHR, and in particular to breach the claimant's rights under Article 14. And that was because for similar reasons as to Brewster. Can we turn, please, to paragraph 80, which is at page 885 of the case. So here the court appeared to address the is a bright line rule justified question. Paragraph 80, it's noticeable that the Home Secretary has not sought to argue that there is any identifiable value in the rigidity of the 5-year rule, but instead relies on the underlying policy of requiring citizenship applications to prove their commitment and connection to the UK, as well as the wide margin of appreciation. Then over the page at paragraph 83, in paragraph 83, the court refers to cases in which it was impossible to prove the connection to the UK in a way which, by presence in the UK on a day when, through no fault of their own, they were prevented from being in the UK. This is focused on Windrush victims who, through no fault of their own, were excluded from the UK. And that happened to be on the day, the 5-year point, at which they needed to show they were there for the benefits of the 5-year rule. And the High Court held, because it was no fault of their own that they were excluded on that day, excluding that particular category was disproportionate. It was discriminatory. In paragraph 84, the court says it's clear that in cases such as these, the government's aims of requiring citizenship applications to prove commitment and connection to the UK could equally as well have been achieved by a less intrusive means, i.e. by applying a discretionary requirement rather than a rigid one. At paragraph 86, for these reasons, making the decisions in the claimant's cases by the application of the 5-year rule with no discretion or flexibility was incompatible with their rights under Article 14 in conjunction with Article 8. it's finally worth just noting that the finding in that case was there is actually a discretion to waive the 5-year rule. There is actually a discretion to grant citizenship in these cases. And the way the Home Secretary erred was by not recognising that discretion. And that's, for your note, it's page 891, paragraph 120. The Home Secretary erred in law when deciding that she had no discretion.
But where does the discretion come from?
It came from the way that the court interpreted paragraph 1 and 2 of Schedule 1 to the British Nationality Act.
So where in the judgment do we see those provisions?
The conclusion is paragraph 120, so that's page 891.
No, I'm not asking about the conclusion, I'm asking about the particular provisions that are said to have conferred the discretion.
So it's a long section that analyses those, and one of the aspects of the analysis is it possible for those provisions to be read in a way, and that starts at paragraph 102.
Right. But it was a simpler question. Where are the provisions set out in the judgment?
The provisions themselves are paragraph 25.
Right, thank you. Sorry, I just didn't ask a clear question. It's my fault. So these are people who were outside the UK at the beginning of the period, or at some date in between. I'm sorry, I'm just not understanding how the facts relate to. It would just be helpful to know what the facts were and why it was said that, how it was said that this discretion arose.
Yes, I think the key facts were just that they were outside the UK on the 5-year point. And
What,
it
throughout
had
the
been,
5 years or for part of the 5 years?
I think just at the point of 5 years before.
No, I can see the provision in paragraph 26. What I'm trying to understand is how the provision related to the facts. Well, don't worry, I can read it later.
Okay, thank you. If I can turn then to my submissions on the basis of that, we say applying that case law here, there was a less intrusive means of achieving the legitimate aims. And the first question is whether the Bright Line rule was justified or not. That's the question considered both in Van Riel and Brewster. And for the reasons that I've already come to, we say the Bright Line rule wasn't justified. So a Bright Line rule which excludes individual consideration of the relevant factors, such as residence, wasn't justified because that consideration occurs in any event. It's equivalent to the Brewster case where the finding was, well, that consideration, the consideration of whether they're cohabiting and whether they're long-term partners occurs in any event, and therefore we essentially reject or give very little weight to the administrative benefits of a Bright Line rule. We say this case is analogous to that one. And therefore it's necessary to look at the particular cohort, or to A's particular case. And we say when that happens, the refusal wasn't justified, essentially for the reasons that I gave in ground 2. So the first one is that the core purpose, like in Brewster, looking at the core purpose of the scheme was to enable family members who were in Ukraine at the time of the invasion, who were put in danger as a result of the invasion, to come to safety to the UK. In terms of that core purpose of the scheme, the appellant is in no different situation as to those who qualify, and that's because he can't return to his country of origin. He is still as in danger as a Ukrainian. Of course, the people in France, the French nationals or the Spanish nationals who can return to their country of origin, they're in a different position in terms of that core purpose, because they're not put at danger as a result of the invasion. the appellant, as he can't return home, it is put in danger and therefore is similar. And so we say that's the sort of central reason. But in addition, no justification has been given for excluding his particular cohort for the reasons I've come to already in respect of ground 2. And so, therefore, there is a less intrusive means of achieving the aims of the legislation. It's not necessary for the court to identify exactly what that means was, but it's relevant to consider what those less intrusive means might have been. One of them is essentially, we say, the same as what happened in Van Riel. So it was for the decision maker to recognise that the discretion in leave outside the rules extended to the facts of his case. So the particular discretion that the decision maker had to grant leave outside the rules, that extends to cases where the appellant satisfies all of the criteria of the scheme other than nationality, and also satisfies the decision maker that they can't return home. An alternative, less intrusive means is just to exercise that discretion on the facts of the appellant's case. I said I would come back to the decision, and I should say that Mr. Holborn has kindly offered, if need be, that I can carry on until 3:30, and with the leave of the court.
That's fine.
Thank you. So just to quickly look at the decision then, to come back to that page of it, as I said I would come back to.
Yes.
It's in the core bundle, tab 21, and page 239. The decision maker gave two key reasons for concluding that refusing leave outside the rules wouldn't breach the appellant's rights under Article 14. And the first of those is in the top paragraph on page 239. It is as follows: that there's a justification for excluding him, for not granting him leave, which is that reserving the Ukraine scheme to those of Ukrainian nationality and their immediate family members is a legitimate and rational way of ensuring that we apply our finite resources to those most in need of our support because of the invasion of Ukraine. Any difference in treatment on the grounds of nationality is proportionate to that legitimate aim. We say that that wasn't a justification for the difference in treatment. And that the main reason is the one I've already come to. The core purpose of the scheme was to protect those in Ukraine on the date of the invasion, to enable them to come and join their family members in the UK. And so far as that core purpose is concerned, there's no difference between the applicants and people who qualify. And we draw support for that submission from the views of the lead minister. So he accepted that. He said there isn't a fundamental difference between the two cohorts. So far as that core purpose is concerned, they're in the same position. So that's the main reason why that justification, that point doesn't justify the difference in treatment. It's also notable that the respondent doesn't rely on this as being a justification for the difference in treatment in their submissions to the court, and the upper tribunal didn't rely on it either. The second reason given for their conclusion is that the applicant wasn't in an analogous position to people who do qualify, and I'll come back to that, if I may, when addressing the respondent's additional reasons. Moving on. Just in case I got it wrong, the date of the invasion, sorry, the date in the Ukraine scheme is 1st of January 2022.
Yes.
I think the date of the invasion was actually February 2022.
Yes.
Yes.
Yeah.
Thanks very much. So moving on then to the respondent's additional reasons for upholding the appeal, and our reply to that. We contain our reply to those additional reasons in our supplementary skeleton, which is in page 1 of the core bundle. The respondent makes 2 points. The first is that the upper tribunal was wrong to hold the circumstances of this case fall within the ambit of Article 8. And we say, no, the upper tribunal was right. The circumstances fall within the ambit of Article 8 for purposes of Article 14 for the reasons that it gave at paragraphs 33 to 36. The law, which the upper tribunal summarises, is as follows. Firstly, it's not necessary to show that Article 8 was engaged in order for the facts to fall within the ambit of Article 8. Otherwise, Article 14 would add nothing to the scope of Article 8. That's accepted by the respondent. See paragraph 16 of its skeleton, referring to the Supreme Court decision in SC, paragraph 39. So it's not necessary to show Article 8 was engaged. That appears uncontroversial. The reason for emphasising this is that then at paragraphs 21 to 24 of their skeleton argument, the respondent makes arguments that Article 8 wasn't engaged, and therefore this case doesn't fall within the ambit of Article 14. And we say that's the wrong approach. One doesn't look at whether Article 8 was engaged. One has to look at a different question in deciding whether it was in the ambit of Article 8. The Article 8 case law is not on point. We say the key question was that which was identified by the upper tribunal in paragraph 34, and it is whether the benefit that's been provided, that's been voluntarily provided by the state, was intended to promote family life, but it necessarily affects family life, or that it demonstrates respect for family life. And the upper tribunal referred to a case of Petrovic against Austria for that, as authority for that point. It's in the authorities bundle. I don't intend to go there if you'd like me to.
If it simply says what you say at paragraph 6, it says you need not go to it.
Yeah, okay, thank you. But if you like the reference, it's in the authorities at tab 29, yes. And it's paragraphs 26 to 29 of that. Another case which supports that, so the question is whether the measure demonstrates respect for family life, is the Supreme Court case of SC. Again, relied on Petrovic. The reference for that, authorities, tab 21, page 797, paragraph 40. Now, in those cases, in SC and Petrovic, the schemes that they were concerned with would inevitably have different purposes. They weren't only, the single purpose wasn't merely to promote family life. They would have other purposes. So to give an example, Petrovic in Australia was about parental leave allowance, and there were particular criteria for when parental leave allowance would be given. And inevitably, one of the reasons for designing the scheme in the way it was to avoid complexity. But the fact that there were different purposes for those schemes wasn't determinative. The key question was whether the scheme demonstrates respect or is intended to promote family life. And if there are other purposes, it didn't matter. We also rely on the more general case law, like the JCWI case, which says that within the ambit should be widely construed. The Royal Cayman Islands case that my learned friend cites, paragraphs 56 and 58 of, it's very important to read on to paragraphs 60 to 64 of that case, because they clarify what my learned friend quoted from it. Those paragraphs stress, again, the wide interpretation that should be given to within the ambit. So the key question here, then, for Article 14 purposes, is the scheme in question, the Ukraine family scheme, intended to promote family life? Does it demonstrate?
You might put the clues in the title of the scheme.
Precisely. We say that's a core intention, intended to promote family life. See the title. See the criteria within the scheme that are focused on allowing families as a whole to come to the UK to join their settled family members. See the preparatory documents that I went to earlier. They're set out in paragraph 6 of our supplementary skeleton. But for example, the equality impact assessment, mentioned the purpose was to avoid splitting families. The aim is to benefit family members of British nationals and settled persons. The respondent submits that the primary purpose of the scheme was to facilitate the return of British nationals from Ukraine by enabling it, making it more easy for their family members to come back with them, and also to avoid complexity that there would be in having a two-tier scheme. And the primary purpose is not to promote family life. And we say that's wrong for the following reasons. Firstly, the previous scheme was concerned, it was focused on facilitating the return of British nationals by making it easier for their family members to come back. But as we've seen, for example, from the Min sub on the 2nd of March, the Ukraine family scheme replaced the previous scheme. And it's necessary for the court to analyse the current scheme, not the previous scheme, in asking what the purpose of the current scheme was. The respondent relies on Mr. Ramsbottom's witness statement at paragraph 5, but it's important, again, to read on in that witness statement to paragraph 6, which the reference is the supplementary bundle, tab 28, page 174, where Mr. Ramsbottom said, the intention behind extending the scope to family members, the intention behind extending the scope of family members to extended family is likewise to keep families together.
Speaking for myself, you're slightly pushing us an open door at the moment.
I'll move on then to the next ground.
Yes.
The question of analogous position.
Yes.
So, was the appellant in an analogous position to those who qualified under the scheme, to Ukrainian nationals who qualified under the scheme? And we say that the upper tribunal was correct to say he was in a relevantly similar position. So that's a different way of asking the same question. Relevantly similar is the same as analogous. And it was correct for the reasons it gave at paragraph 37 to 39. Looking at the law, first, the upper tribunal at paragraph 37 explained that in asking whether one group is in a relevantly similar situation to another, the key question is whether they were in a relevantly similar situation as regards the purpose of the scheme. So one focuses on the underlying purpose, the core purpose, and asks whether there was a difference between them so far as that purpose was concerned. The upper tribunal referred to the case of McLaughlin, which we've been to. Another authority for that is the case of SC, Supreme Court case of SC, authorities page 802, paragraph 59. One focuses on the purpose. The other aspect of the law which the upper tribunal correctly referred to is the AL Serbia case, which noted that it was only in a handful of cases where there was a finding that there was no breach of Article 14 on the basis that the two groups weren't in a relevantly similar situation. And she said, therefore, the courts should not hold that they're in that they're in different situations, unless there's very obvious differences. One needs to see obvious differences before cases will be rejected on this basis. At paragraph 39, the upper tribunal again correctly gave its reasons why there was no obvious or material difference between the appellant and those who qualify as regard the core purpose is concerned. And I'd just like to expand on the reasons it gave. We say there was no material difference between the appellant and those who qualify. The only distinction between the two of them was nationality. So he met all of the criteria within the scheme apart from nationality. But of course, in deciding whether two groups were in an analogous situation, nationality has to be left out of account. Otherwise, this would defeat all discrimination claims. That point is also clear from the authorities. We quote in the skeleton argument, or we refer to the case of Dabi against Italy. Could we just briefly go to that? It sets out the position very clearly. It's in the authorities bundle at tab 32, page 1105. This case concerned an allowance given to large families on low means, but only if they were Italian nationals. At paragraph 49, the court further observes that the refusal to grant the allowance was based exclusively on the nationality of the applicant, who at the time was not a national of the European Union member state. It was not alleged that the applicant did not satisfy the other statutory conditions for entitlement to the benefit in question. Hence, it's clear that he was treated less favourably than others in a relevantly similar situation on account of a personal characteristic. So it's finding there that they were in a relevantly similar situation. So our main argument, the core purpose of the scheme, again, is to protect those in Ukraine impacted by invasion, family in the UK. There's no material difference between the appellant and Ukrainian nationals who qualify. The respondent points to a number of distinctions at paragraphs 30 to 35 of a skeleton argument, and we say that none of those are sufficiently obvious distinctions as regards the purpose of the scheme. So the first one in paragraph 30, the respondent argues, is that the applicant didn't have a permanent right to reside in Ukraine. And the respondent argues that this means that there is a sufficient difference, which means the two groups aren't analogous. I've already really covered this in the context of the justification point, but we say that's not a sufficiently obvious difference so far as the purpose is concerned. And that's in part because a potentially large number of people qualify for the scheme who don't have permanent right to reside in Ukraine. So under paragraph 7.1b, we've seen a potentially large group of third country nationals can qualify, and there's no guarantee that those will have permanent rights to reside. A large number of them may have temporary rights to reside. And to look at the matter in a different way, that there's no criteria requiring permanent residence in order to fall within the scheme. Even if the applicant had permanent residence, he wouldn't fall within the scheme. And we rely on those points as evidence to show that the core purpose of the scheme wasn't to limit it to people who had permanent residence. Therefore, so far as the core purpose of the scheme was concerned, there wasn't a material difference as between the appellant and those who qualified for it. I should just briefly note the appellant. We don't accept what the respondent says, that the appellant only has an outside possibility to return. He was declared a refugee. There was the presidential decree extending visas of those with temporary residence until after the conflict. We don't accept.
Sorry, he was declared a refugee in Ukraine.
Yeah.
When was that?
So it's covered in the tribunal's judgment. I think it's paragraph 2, noting that he could not return to Afghanistan. And on 1st of September 2021, he was recognised as a refugee by the UNHCR there. And I hope I can just deal very quickly with the other distinctions that the respondent seeks to draw in arguing that the appellant wasn't in an analogous situation. Paragraphs 31 and 34, the respondent draws attention to practical difficulties in assessing residence or the ability to return. And the main response is that's not a distinction so far as the core purpose of the scheme was concerned. And SC McLaughlin say we have to look at the core purpose. There weren't any practical difficulties in this case, so he's not in a different position from those who qualified in that sense. At paragraph 33, the respondent argues that the primary purpose is to facilitate the return of British nationals and to avoid complexity, and for the reasons I've already given, we say that's not the primary purpose, and therefore that's not relevant. At paragraph 33, the respondent also argues that the appellant could travel to a safe EU country, and therefore that puts him in a different position from those who qualify, but the reasons given earlier, he's in exactly the same position as those who qualify. All of them could travel to a safe EU country from Ukraine just as he could. The final argument is about risk of abuse. So in paragraph 34, the appellant argues that there was a risk of abuse of people who weren't resident in Ukraine coming in through an expanded scheme. Again, the question is whether there's a difference between A's case and those who qualify. In A's case, he was found to be resident in the Ukraine. It can't be suggested that there's a risk of abuse in merely concluding that he should be given leave. And so the question as to whether he's in a relevantly different situation to those who qualify, so far as the risk of abuse is concerned, the answer we say is no, because he was clearly resident. So that's all I'd say in response. And in conclusion, we invite the court to quash the Upper Tribunal's judgment and to grant the remedy which is set out in paragraph 67 of our skeleton argument. The remedy is focused on the decisions in A's particular case. So it's declared that the decision to refuse to grant a visa to A was unlawful as being incompatible with Article 14 and Article 8. And that's the primary remedy we seek in this claim. Unless there's anything else, those are my submissions.
Miss Nall? Right. Mr. Haben, shall we take a 5-minute break and we'll hear from you at 3:30?
Yeah, yeah.
I'm sure.
Yeah, it just means
Yeah.
you know, normally you just sit and wait and wait and wait.
Court rise.
Yes, Mr. Hayden.
My lord, if I may make some preliminary observations as to the scheme and then set out the headlines to my submissions that I wish to make. We'll see how far we get then. If maybe you have questions I can take away and I can pithily deal with the balance in the morning, but I'm conscious I'm maybe not my best to give every assistance on every question you may have. So dealing with the scheme, and by scheme I mean the immigration rules plus any express concession in policy. I accept, of course, that there is a residual discretion that exists for any scheme under the immigration rules where there are bright lines. But that residual discretion doesn't encompass or necessarily encompass consideration or analysis or investigation to the degree contended for by the claimant. It may include concession outside of policy. You will note that this scheme began life as a concession without there being immigration rules in place. It began operation on 4th of March. The immigration rules that you have seen didn't in fact come into force until later in the month. Hence you have the 24th of March ministerial submission referring to these third country national applications. At a point at which there hadn't actually been, I don't recall if the scheme was yet in the rules on the 24th of March, but it was only around that date. Applications have been coming in.
Sullivan will check that for us.
I will double check that for you. There is, of course, one reference to the exercise of discretion as well in the policy in respect of family members and the width of family relationships, which I can refer you to as well. There is not a discretion, though, identified in the guidance specific to nationality requirements. So the scheme has been set up deliberately to not include a concession for the cohort of third country nationals within which LR is part of. Now, there are various reasons for that, and we've been through the ministerial submissions, and I'm not going to repeat that or take you back to those unless it becomes necessary. Our position on those submissions and the comments of Minister Foster in particular, I think, is set out in the skeleton argument, but that represents, in my submission, discussions between the minister and civil servants. Points made by the minister pushing back on civil service advice, testing that advice. Ultimately, the only conclusions reached are the positive decisions that are made, and in particular the positive decision made after the 6th of May ministerial submission. All of those comments in the April email come under the heading of "I would like further advice on this." They are discussion points. The only real bearing they have, or this kind of discussion might have, is to show what matters were and were not considered in the decision-making process. And my learned friends authorities, that is what my learned friends authorities are referring to when they are considering analysing the questions of reasons for coming to a decision. So those are my headlines on the scheme. Moving on to Article 14 itself, we've obviously put in a respondent's notice raising 2 additional grounds. I should flag that one of the key reasons for that is it appears to the Secretary of State somewhat artificial to consider the question of Article 14 only through the lens of the 4th limb of McLaughlin, the justification limb. My junior has helpfully handed up that the date of the immigration rules change was 22nd of March 22.
Is that presumably the date when it was laid?
Date it was laid.
Rather than when the period of whatever it is, days expires?
Yes, I don't know whether indeed. We'll double check. We'll double check.
Yes, you were saying Article 14.
Article 14.
I'm sorry to
Yes,
interrupt.
not at all.
Is there in fact a respondent's notice? Because I was looking in the bundle for one and I couldn't see one.
Made it into the bundle. I know I drafted one.
Oh, there is that. There actually one actually exists, does it?
It'll allow you to give evidence on that point, but it doesn't seem to have made its
Because one of the
way.
points we raised on ourselves is
Full
the respondent's
bundle.
notice. Is it in the supplementary bundle? Because I would have expected it to be in the core bundle.
Yes. Not a point that I hadn't spotted. It wasn't there.
No, it doesn't look as though it's the sort of thing that would be in the supplementary bundle. Well, if there is a response notice, I think we'd quite like to
Yes.
have a copy of it.
We must obviously have it. Could Miss Sullivan send it to one of our clerks overnight? And I hope that Mr. Straw and Miss Knorr have had it. I don't imagine it will tell us anything that we don't know from the amended, from the supplementary skeleton arguments. But
Yes.
anyway, we'd better have
Thank
it.
you.
I saw Mr. Straw nodding.
Yes, good. Quite right.
And Miss Knorr behind him.
It's not. No, we have a statement as to why PTA should be refused, but we haven't got a response. All right.
Well, the points raised in the respondent's notice were simply to add back the points of ambit and whether or not Elar's in an analogous position to Ukrainian national to consideration.
Yes.
And obviously we wouldn't raise those points if we didn't think those arguments had merit, but
Yes.
but it is, particularly in the case of the analogous position argument,
Yes.
it is somewhat artificial to distinguish that from the justification arguments because they very much overlap. The ambit, I accept, sort of sits in its own box a bit more clearly.
Well, my impression, for what it's worth, is if you're reduced to relying on the ambit point, you're in trouble. But you can make of that what you will.
Yes, and I will give you perhaps one line as to why I say, and I hope to provide a reference to a couple of authorities tomorrow, why I say you can say this is not in the ambit, because accepting entirely the point about there being a label on this of family scheme, in my submission that is a reference to it's a reference to a class of person, not a reference to family life, and it's intrinsic indeed in the scheme that it affects a large number of people for who do not have family life at all. Whereas the normal position for a scheme which is said to have a more than tenuous link, such that it falls within the ambit, is that it will have in every case of the exercise of the scheme some bearing on the modalities of family life. Parental leave, for example. Now, it may not in reality engage, because of the decision made, not engage the right in the particular circumstance for whatever reason. But it fundamentally is, when we would say a policy falls within the ambit of an article, it must mean it is directed towards the right, the articulate right, not that it is a policy that happens to catch people in the category who may have articulate rights, and the fact that it may affect or interfere with articulate rights. That's the distinction we draw.
But actually what this policy requires is two people who are in the same family but have taken, it may require more, but it requires at least this, two people who are in the same family who have taken a conscious decision to live in different countries.
Indeed. So by definition, a large number of the individuals will not be have family life. Now, of course, I accept what was said by the claimants that at the start of this scheme, one of the purposes was to, in relation to British nationals who may be in Ukraine, who are returning, who may have had family life engaged. But that was only one of the category of persons when the scheme was developed. Once the scheme is fully formed, it is exactly as your Lordship says. It is referenced, in fact, predominantly to a category of person who do not have family life. If I may just get into the headline then on analogous position. Our position is that my learned friend's construction of the purpose is not quite correct. It is, in one sense, slightly too wide. It is, of course, directed at helping people who are at risk in Ukraine and their family members widely defined. But ultimately, the purpose of the scheme is to assist those who fall within it. And that does not include, on the face of it, the rules. The appellant. The focus
Surely
is on
that's circular. I mean, to say purpose of the scheme is to assist those who are within it doesn't tell you whether somebody who is outside it as drafted is in an analogous situation to people within it.
Yes. No. I accept. I accept that. In some ways, it's one of the reasons it bleeds into justification.
Yes.
But the point is there are material characteristics that explains why the Secretary of State has made a decision to help these individuals. The focus being, as a starting point, being firstly British nationals coming back from Ukraine, then helping Ukrainian nationals. That's the focus. It happens to be the case that third country nationals who are family members of Ukrainians are also helped along the way.
Are there any cases that help us to decide how one works out what the principal purpose of a scheme like this is?
That is a question that had occurred to me during the course of today, and I hadn't yet come up with an answer.
Well, that's perhaps something you could think about overnight,
yes.
because I mean, Mr. Straw has a particular view about what the purpose of the scheme is, but I'd just sort of like to know how one tests that and how one gets to the right answer, or if there's a range of right answers, how one gets into the right ballpark.
Yes, I see the point. And I can see that goes to both analogous position and justification. But in summary, we say that Mr. Straw's characterisation of the purpose is perhaps a little wide, because you have to read, and this is where the justifications come alongside it, that the purpose is to help a category of person who we can also, for example, in general, maybe not universally, but in general, can be expected to leave the UK at the end of their period of time here, who generally speaking cannot go to another country. So that's my position on analogous, whether LR is analogous. In terms of justification, I think we've touched upon all the various justifications, the risk of abuse, the issue of future removability or future leaving the UK, for which I'd highlight this is not a settlement scheme. That's an important part of the rationale here. And our position is these justifications must be read together. It's not just one that stands alone. They are a series of issues that arise when you attempt to move the bright line. Because that's what, in essence, Mr. Straw, what's happened is the bright line moves. It moves to encompass his client and people, hopefully, probably some other people in that category, in one way or another. The reasons why that was not a good idea were discussed in the ministerial submissions we've gone to, including the reasons why Minister Foster's proposal in his April email or suggestion that maybe we should more tightly draw the criteria to immediate family, and we say that what he was referring to was immediate family, was not a wise thing to do in the view of civil servants. And he accepted, ultimately him and the Secretary of State looked at the submission and accepted that and made the decision not to create the concession. See if I may then give what might be my headline points responding to the individual grounds. in terms of ground 1, these are the grounds as set out in the skeleton argument. In terms of ground 1, in short, there just was the suggestion that justifications had been rejected by the minister is just not correct on facts. What you see is a discussion and the minister testing those justifications. In terms of ground 2, we do rely upon AB, and we say our position is it is rational to have a bright line rule here. Mr. Straw accepts that that's the test identified in Re G. I think your lordships have already identified the issue with his heavy reliance upon the residence question, which is that, of course, in this context, the Secretary of State has made a decision that she can take a light touch approach to residence. And in general, that will be undermined if it's moved towards third country nationals being able to apply as of right. That's a very different position to the risk of abuse when you have third country nationals who are family members, who already have established a link to a Ukrainian national, an identifiable Ukrainian national. The mere existence of the outside of the rules scheme, backup scheme, doesn't assist either, because that does not necessarily involve the kind of detailed consideration necessary to make decisions in cases like this, either as to residence into Ukraine, safety on return to their home country, right of return to Ukraine, which is of course also important. To note in this case, we don't have clear evidence as to what, even if the LR has status as a refugee, there's no evidence as to what that really means as a matter of Ukrainian law or returnability. So we say the bright line rule is justified. This is ultimately has to be looked at on a scheme-wide basis. Is the scheme justified? It is. Ground 3, the response is extremely short. It's wrong to characterise the upper tribunal's judgment as making a finding that there would inevitably be an Article 14 problem by some heightened evidential requirements for third country nationals. And indeed, it'd be quite surprising if they had gone on and done so, bearing in mind we had limited argument. And of course, as your ladyship identified earlier, these are rules which have to apply to a whole scheme, to a range of third country nationals. That's not the point made by the tribunal, nor indeed the concern of the Secretary of State per se. It's not saying there will be a finding of discrimination. It's the risk of challenge. And the upper tribunal, in my submission, rightly was finding that that was a relevant element of justification. final element of less intrusive measures in my submission amounts to no more than an allegation that there should have been a different bright line. The Secretary of State has ultimately made a rational decision that this is the bright line rule that she will choose. Now, my lords, are there any particular points that you would like me to address beyond authorities, particularly on purpose? I have that point. I know I need to take you some points on.
I don't think we've got to that stage. We might in the morning come back with,
Of course.
oh, we'd really like to hear you about X or Y or Z. At the moment, I think you should take whatever course you think best.
Thank you. In which case, I think I would appreciate resuming again in the morning. I understand that we lose time, but I hope to gain back time by being more.
Yes, well, that sometimes happens. And, all right. Well, if my colleagues don't have any questions at the moment, we'll say 10:30 tomorrow.
Thank you.